Hello, future lawyers, and to everyone who is watching this video. Today, we're going to learn what probation law is all about and is also known as Presidential Decree Number 962, as further amended by Batas Pambansa Bilang 76, Presidential Decree Number 1990, and Republic Act Number 10707. This topic shall be presented by the Group 5 in the order of Ms. Linending, Ms. Aradani, Ms. Mauti, Ms. Zakaria, and very yours truly, Ms. Deyuha. I hope that you will learn a lot on this topic. Enjoy!
What is probation? Probation is a disposition under which a defendant, after conviction and sentence, is released subject to condition imposed by the court and to the supervision of the probation officer. Nature of order granting probation. An order placing a defendant on probation is not a sentence, but it is rather in effect a suspension of the imposition of the sentence. In the case of Baclayan versus Mutia, the court said it is not a final judgment, but it is rather an interpretatory judgment in the nature of the conditional order placing a convicted defendant under the supervision of the court for his reformation to be followed by a final judgment of discharge if the conditions of the provision are complied with, or by a judgment of sentence if the conditions are violated. Purpose of decree establishing a probation system. The threefold purpose of the decree is to, number one, promote the correction and rehabilitation of an offender by providing him an individualized treatment. Number two, provide an opportunity for the reformation of a penitent offender, which might be less probable if he were to serve as a prison sentence. And number two, the probation law. When shall the application for probation be filed? What the law requires is that the application for probation must be filed within the period for perfecting an appeal. Republic Act Number 10707 amended Presidential Decree Number 968 by allowing an application for probation if appeal is filed for non-probationable penalty and penalty imposed on appeal is probationable.
One landmark case in relation to this is the case of Colinares versus People, wherein the accused, Arnel Colinares, was found guilty of frustrated homicide and he was sentenced to a penalty which did not qualify him to apply for probation. On his appeal to the Court of Appeals, the CA affirmed the RTC decision, but when he elevated the case to the Supreme Court, the SC held him liable only for attempted homicide, which imposes a penalty that would allow him the right to apply for probation. Hence, the issue to this case is whether or not the accused is entitled to probation, considering that Section 4 of the Probation Law provides that no application for probation shall be entertained or granted if the defendant has perfected the appeal from the judgment of conviction. The Supreme Court held in this case that yes, the accused may apply for probation. The stiff penalty that the trial court imposed on him denied him the choice between appeal and probation, and it remains that those who will appeal from judgments of conviction, when they have the option to try for probation, forfeit the right to apply for that privilege. Basically, what we can take away from this case is that the probation law never intended to deny an accused his right to probation through no fault of his. The underlying philosophy of probation is one of liberality towards the accused, and such philosophy is not served by a harsh and stringent interpretation of the statutory provisions.
Under Section 8 on probation law, the court shall consider all relevant information in determining whether an offender may be placed on probation. When is probation denied? If the court finds that 1. The offender needs correctional treatment which can be provided most effectively by committing him to an institution. 2. If there is an undue risk that the offender might commit another crime during the period of probation. And 3. If the probation will depreciate the seriousness of the offense committed. The grant or denial does not rest solely on the offender's potentiality to reform, but also on the observance of demands of justice and public interest. Who are the offenders disqualified then from being placed on probation? 1. Those sentenced to serve a maximum term of imprisonment of more than 6 years. Question: can Pedro be qualified for probation if he is convicted of multiple prison terms, the sum of which exceeds 6 years? The answer to that is yes. As long as none of the terms exceeds 6 years, he may still be qualified for probation. The basis of disqualification is principally the gravity of the offense committed and not the number of offenses. 2. Those convicted of any crime against national security. 3. Those who were previously convicted by final judgment of an offense punished by imprisonment of more than 6 months and 1 day and or a fine of more than 1,000 pesos. 4. Those who were once recipients of probation, because the privilege of probation can only be availed once. 5. Those who are already serving sentence. And 6. Those who have perfected an appeal. Even if the offender is qualified, probation may still be denied because its grant is not automatic. It is a privilege and its grant rests upon the discretion of the court. As a general rule, an order denying probation is not appealable, except when there is a grave abuse of discretion, in which case a petition for certiorari may be filed. That's all for the second part.
So now
Thank you
let's
for listening.
proceed to the conditions of provision listed in the Section 10 of the said provision law. So these are the conditions we have to follow in case we are subjected to provision. So these are mandatory and discretionary conditions. So what are these conditions, by the way? Okay, so first we have mandatory conditions. Provision orders shall contain conditions requiring provisioner to present himself to his supervising provision officer at the place specified in the order within 72 hours from receipt of said order. So which means that the convict must present himself to the designated provision officer within 72 hours upon receiving the notice of the said order. Second is report to the provision officer at least once a month at the time and place specified by said provision officer. So which means that the convict or the accused as the provisioner must present himself to the designated provision officer at least once a month within the period of the provision or sooner. Take note that these conditions said to be mandatory, which means that if it is violated, the provision will be terminated. Second is discretionary conditions. Other than those conditions listed in mandatory are all discretionary conditions. Provision statutes are liberal in character and enable courts to designate practically any term it chooses as long as the provisioner's constitutional rights are not jeopardized. Same with Baclayon versus Mutia, it said that the conditions under Section 10 are not exclusive or exhaustive, which means that the court may impose any conditions as long as it does not violate the constitutional rights of the provisioner. Note that under discretionary conditions, the additional conditions should be realistic and purposive, and it will help the provisioner to be a law-abiding citizen or better citizen as a whole. Thank you.
So for how long may a convict be placed in probation? If the convict is sentenced to a term of imprisonment of not more than 1 year, the period of probation shall not exceed 2 years. In all other cases, if he is sentenced to more than 1 year, said period shall not exceed 6 years. When the sentence imposes a fine only and the offender is made to serve subsidiary imprisonment, the period of probation shall be twice the total number of days of subsidiary imprisonment. So what are the effects of violation of probation order? Upon the failure of the probationer to comply with any of the conditions prescribed in the order, or upon his commission of another offense, he shall serve the penalty imposed for the offense under which he was placed on probation. Section 11 of Probation Law provides that the commission of another offense shall render the probation order ineffective. Based on the foregoing, the CA was correct in revoking the probation of petitioner and ordering him to serve the penalty for the offense for which he was placed on probation. So when may probationer be arrested and what is his position once he is arrested? Anytime during probation, the court may issue a warrant for the arrest of probationer for any serious violation of the conditions of probation. The probationer, once arrested and detained, shall immediately be brought before the court for a hearing of the violation of the charge. In the hearing, which shall be summary in nature, the probationer shall have the right to be informed of violation and to adduce evidence in his favor.
When and how is probation terminated? Now, after the period of probation and upon consideration of the report and recommendation of the probation officer, the court may order the final discharge of the probationer upon finding that he has fulfilled the terms and conditions of his probation, and thereupon the case is deemed terminated. Now, what are the effects of the termination of probation? The final discharge of the probationer shall operate to restore to him all civil rights lost or suspended as a result of his conviction, but it must be taken note that probation is not coterminous with its period, because the expiration of the probation period alone does not automatically terminate probation. There must be first issued by the court an order of final discharge based on the report and recommendation of the probation officer. Now, prior to the amendment of Probation Law by PD number 968, the effect of final discharge of probationer restores all civil rights and to fully discharge his liability for any fine imposed. But now, with the amendment by RA number 10707, it totally extinguished his criminal liability instead of merely fully discharging his liability for the fine imposed. It basically means that extinction of criminal liability does not necessarily mean that the civil liability is also extinguished, as held in the case of Petralba versus Sandigan Bayan. We should take note that probation affects only the criminal aspect of the case, and the suspension of the sentence imposed on the accused who is granted probation has no bearing on his civil liability, because the court must hear the civil aspect. Now, what about the penalty on Moros and non-Christians? It is found in Section 106 of Administrative Code of Mindanao and Sulu, and this is a matter of reading. In relation to this, basically what the court says in the case People versus Pawin, the application of Section 106 of the Administrative Code of Mindanao and Sulu is discretionary to the court. Moreover, where the accused appellant is a Mohammedan inhabitant of Mindanao, the penalty to be imposed upon him, regardless of the attending circumstances, lies in the discretion of the trial court pursuant to the same provision as held in the case of People versus Disimban. Also, in the case of People versus Cowell, the court is granted discretion to impose the proper penalty, taking into consideration the degree of instruction of the Moros without following a fixed rule. The Igorots are in worse condition than the Moros. The latter are Mohammedans and the former pagans. Their culture in embryonic stage is subject to their savage spirit, and the lack of instruction among the Igorots should be considered as a mitigating circumstance. And that ends our report about probation law. I hope you were truly enlightened by our discussion. Thank you so much, and goodbye.